Hello and welcome again to another episode of Sacktown Talks. Today we have a special guest joining us, Tim Sparapani, attorney, talking a little bit about Prop 22 and kind of the ongoing litigation. Tim, how's it going? And thanks for joining us.
It's great. It's a pleasure to be with you. Thanks for inviting me to come and talk about this important issue.
No worries. I guess for our listeners who don't know who you are, can you give us a little background on yourself?
Sure. I'm a practicing attorney, policy advocate. I've been doing legal work for about 22 years. I'm principally a constitutional lawyer. I have been practicing constitutional law at the federal level and at the state level for my entire career. Worked at the ACLU, the American Civil Liberties Union, where I've done a bunch of work in the tech policy space. And that led to me doing some work, obviously on behalf of consumers everywhere. Early on, I was hired by Mark and Cheryl to be the first head of public policy at Facebook. That was a long time ago. So I advised them many, many moons ago and left before the IPO of the company. So I like to say that when they were listening to me, things were going really well. And when they stopped, well, you see what happened. So in the last 10 years, they've been on their own. But for the last 10 years, I've been advising consumer and privacy advocates and a bunch of tech startups about really important questions in public policy. And currently, I am also a senior policy fellow at an important organization called CALInnovates.
Okay, great. So kind of to dive in a bit to Prop 22, let's first go back and kind of talk about what led to Prop 22. And it kind of all started with this Dynamex decision, which was about 5 years ago, if I remember correctly. Can you kind of give us a little background on Dynamex, how it became about, and kind of why it led to this kind of, issue of AB5, which then led to Prop 22?
Yeah, no, it's really a tangled situation that got us here in California. So look, labor law is really a dynamic thing. Hence the Dynamex case is really important, right? And nowhere more so than in California. And so in 2018, the California Supreme Court took up the important question of how or whether to classify workers as either employees or independent contractors. And this really seemingly innocuous question is really quite important. It matters for the individual. It matters for their benefits, their taxes, what options they've got as employees, what rights they have, but it also matters to the employer, how they treat the employee, what things they have to do, responsibilities and duties they owe to the individual who they've got in their employ. And so the court looked at the standard which it had been in place in California, the legal standard in a case set back in 1989 called Borrello, and said, oh, no, we're going to redo this and we're going to do it a whole different way. So in this 2018 case called Dynamex, the California Supreme Court came up with this new rule, which they borrowed from states out east, Massachusetts and New Jersey, a common test. And they said, we're going to presume that everybody's an employee and not an independent contractor, unless there's another test that's been met. There's a three-part test they established. We can talk about that in a second. But the consequences are that the employer who wanted to make somebody an independent contractor would then have to bear a burden, a legal burden, to show that anyone who they were saying was an independent contractor was in fact meeting this three-part test, or they would have to treat them as an employee. And that really was important because when this was happening, this is really the boom time, the initial boom time for the gig economy, right? Everybody getting into, DoorDash and Uber and Lyft and all the other things that we've come to find to be so important and that were really quintessentially part of our economy just before COVID took over, and that so many millions of Californians had made part of their livelihood. So you might ask, what was this important test? Well, there's this three-part test that the California Supreme Court put in place, and it's kind of hard to describe briefly. But I'll do my best. It's called the ABC test because it needs an acronym because it's so darn long. But it basically asks three different things. Is the individual who wants to be classified maybe as an independent contractor, or who the business wants to classify as an independent contractor. Is that person, are they free from the control and the direction of the hiring entity in terms of how they're performing their work? That's the A part of the test. If so, B, are they performing work that's different or outside of the usual course of what that business is doing? So are they doing something that's really different than the normal business that the business is doing? So not the run-of-the-mill day-to-day activity, so that they would be being employed to do something totally different or unusual that would make them not a normal everyday worker. And then if so, A and B, then C, is the person then customarily engaged who is coming to work in an independently established trade? Are they somebody who is doing something where the custom in that trade is to be employed as an independent contractor rather than as an employee? Are they a craftsperson, a tradesman, somebody where we typically hire people to be independent contractors? Are they an Uber driver? Are they a Lyft driver? They work for DoorDash. If they're A, B, and C, then the presumption shifts, and that person can be classified by the entity that's paying them as an independent contractor rather than an employee. And this is a really big sea change from how all California businesses, had been classifying people up until this decision in 2018.
Yeah, and so in response to this court decision, the legislature comes out and they state, we need, AB5, we need to do something. And so they came out and they rolled out AB5. For our listeners, what did AB5 do?
Well, it just made it a muddled mess. I mean, I'd like to say that it clarified the decision, but Californian legislatures tried to carve interesting exemptions out, right? And they said, okay, if you're in certain kinds of industries, maybe you'll be, pulled out of this if you do certain kinds of work. And I think it just confused a lot of people, right? They tried to clarify the situation, but in clarifying the situation, it just got more garbled, right? So like no good deed goes unpunished. Things got more difficult rather than less clear. And so I think a lot of people felt there wasn't a good, clear standard to apply, right? And so we had a lot of people, especially as the economy was getting more and more dynamic, as new businesses were arising, as there was innovation, especially coming out of California with new ways to work, new flexibility for people to get hired, new jobs, new opportunities for people to earn income, especially on the side, with flexible, kinds of employment. The AB5 test overlaid with this new ABC test coming out of Dynamex, a lot of people just kind of threw up their hands and said, we don't really know what's going on. So,
right. And I remember, just as the beginning of 2020 hit, the end of the year, you had all these independent writers and everyone kind of freaking out about losing their independent contractor gigs and not being held on as employees. And, additional carve outs were sought. But, I guess at the end of the day, were people, industries or independent contractors any better off, with AB5 than with just dealing with the Dynamex decision?
It's really hard to say. I'm sure some were, some weren't. And, but I think in the main, what happened is there was just worker confusion. There certainly was employer confusion, right? And when you don't have a clear, bright line to apply, especially at the scale of California's economy, you don't really have something that's workable. And I think out of that led a desire from, a lot of people to set in place a new, clear, bright line. And because of California's, important and unique ballot initiative situation, there was an opportunity to sort of rethink and put a new bright line test in place that everyone could sort of understand. And so along came Proposition 22.
So can you explain to our listeners, what's the big deal? You always hear okay, so you're an employee, you're an independent contractor, what does it matter to you? Why does it matter if a company is paying you as an independent contractor or an employee? Why does it matter to that company?
Well, why does it matter to the employer?
No, to the company. Yeah, the employer. Yeah.
Well, for the employer, it'll matter for tax purposes. If you're an employer, anything that you're doing as an employee, they write off. They take your wages and they write them off. And so that reduces the taxable burden of the employer. But also they have other responsibilities on the contrary. They have to pay for benefits. So, there are burdens that are commensurate with having employees. They have to, meet certain responsibilities to take care of their workforce. And, they have to pay leave and provide, all sorts of benefits. It's been important, both to protect workers, but also to set a fair set of responsibilities for the employers as well. So, having an employment status can be really meaningful in both situations, and it can be desirable in some situations and not desirable in others, right?
So, as you were kind of alluding to, out of kind of the unclarity of AB5, and I guess the inability for, AB5 to address the gig economy, out came Prop 22. Why was Prop 22 necessary for kind of these gig economy companies?
Yeah. So I think the companies or the gig economy companies were really trying to find a way to have these millions of people who had flocked to this, side hustle economy, where they or principal economy for some people, economy where they were taking jobs whenever they could, driving, doing odd jobs, where they were fitting in work around their own other responsibilities in their lives, maybe childcare, maybe education, maybe taking care of a family member who was sick. And so for these businesses that had become these gig economy juggernauts, they were looking at having to reclassify perhaps millions of employees in a totally different status, where they were going to be presumed to be employees, and then have a totally different relationship with all these different companies that were arising, TaskRabbit, DoorDash, et cetera. You'll go right down the list.
Right.
And what that meant is that those businesses were probably going to have a lot less flexibility, and that the people who were, really seeking out those kinds of employment and the flexibility, were going to lose some of the flexibility that they had been seeking, right? And so what had been working and what people had really been running towards to create extra income and find new opportunities to really supercharge their own income in their own ways, around their own lives, with their own decisions, was probably going to be upset. So I think a lot of people sought Proposition 22 as a way both to have a clear, bright line, so that everybody could understand what the rules of the road were, instead of this, like, are you on one side of the exception, are you the other, and what's the test, and to give these people who want, all the millions of people who wanted to avail themselves of the gig economy, the opportunity to have the flexibility that they had sought, and that they clearly needed for their own choices for how they were going to raise money for their own lives.
Right. So, I guess for our listeners at home, can you kind of describe in detail, I guess, what Prop 22 would have done or would do?
Well, I think the details are a little bit hard to go back in, but basically what it would have done is it would have, again, given back the flexibility. And so it was a statewide ballot initiative, and the statewide ballot initiative, again, would have allowed people the ability to be reclassified easily as independent contractors. So it takes this proposition and this presumption set in place by the court decision in Dynamex, and it says, no, we're taking this out of the way, and we're going back and saying, there's a simpler test, and we're going to assume that a business can basically decide whether somebody's an independent contractor or whether or not they're an employee based on the kinds of work they're doing. And so it gives more opportunities back to the employee and the employer to have a dialogue about what kind of work they want to do. Mm-hmm. And so it kind of gives the primacy back to the individual to have a negotiation with the company they're talking to, and sort of puts the individual back in charge, rather than this sort of bright, this other standard that was sort of opaque and sort of nebulous and hard to understand, right? Or that might have presumed that somebody was an employee when in fact they were an independent contractor. So, and a lot of people wanted that, right? And clearly that's the case. And I'm not a Californian, but if we look at the votes, what's clear is that 59% of Californians voted for this thing. 10 million Californians voted for Proposition 22. And so that's a lot of people and a pretty decisive vote on a ballot initiative. And so it feels like it's a really decisive statement from the California voting populace about a desire for greater flexibility and a real endorsement of the gig economy, and less of a desire for there to be sort of by stamp a decision that says everybody has to be classified by presumption as an employee.
Right. I guess what were some of the arguments against Prop 22, and why has it continued to be contentious if it had such a kind of overwhelming support?
Well, so the arguments are what you would normally expect, and I say this as a consumer advocate. The assumptions were that somehow the businesses that were the gig economy companies were taking advantage of the employees by not providing them with extra benefits, by not they were naturally suppressing the wages by allowing anybody into the driving pool or anybody into the grocery buying pool or whatever the gig economy service was, and so wages were unnaturally suppressed. Part one. Part two, there weren't any benefits, so you had all these people working all these hours, and the argument was they weren't getting the opportunity to have healthcare. They weren't having the opportunity to get paid leave. If they got sick, there wasn't a union behind them. Like there wasn't like the fulsome set of worker rights that would come with being in a full-time employment opportunity. So it's a question of flexibility on one hand versus automatically being provided benefits on the other. Some of the more innovative companies were saying, okay, no, we hear you. We're going to start giving you more and more benefits and rights. And in fact, Proposition 22 mandated some of those basic requirements. So it wasn't like after Proposition 22 was put in place, there were actually a lifting of worker standards mandated by Proposition 22. So I think Californians said, yeah, we hear you. And we want both of these things. We want both flexibility and we want some standards to be put in place to protect consumers. It seemed like it was a pretty good balance that was struck.
And so kind of as you alluded to, Prop 22 passes, overwhelmingly 59%, a lot of money spent on both sides.
Tremendous amounts, right?
And kind of life went on and we thought this was the lay of the land, but lo and behold, a lawsuit was filed challenging the proposition on a constitutionality grounds. Can you kind of tell us a little bit about the lawsuit, who filed it, and kind of what the theory was?
Yeah, well, so the theory is really what matters here, and the theory here is that there were two or more different subject matters in the same initiative, so that voters could not possibly tease apart what they were voting on. So that there were multiple subject matters, and voters weren't voting on one clear thing. And so an Alameda County judge decided to strike this down as unconstitutional and said, listen, the voters didn't have a clear decision here. I'm gonna enjoin this and I'm gonna strike it down. And doing so froze the whole situation again and threw this all back into chaos. So we're back kind of in the soup. And that's an interesting position to be in. Again, when you have 10 million people who voted to sort of set a new balance. As a constitutional lawyer, I sort of wonder how a judge can set aside the democratic will of 10 million people. We have all sorts of ballot initiatives. If you look at California history, where there's multiple subjects. And if you read even one set of ballot initiatives from any election, they're paragraphs long, right? Every ballot initiative, you go into the California voting rule, if you look at it, I've done this just as somebody who's interested in the subject matter. Each of the ballot initiatives is paragraphs long, right? At times, right? So the idea that like this particular ballot initiative has more than one subject, and that's the reason it's unconstitutional, strikes me as a little bit of a reach from a legal standpoint as justification. But that's the principal reason that this judge has paused implementation of Proposition 22.
It was interesting when that case went out, everyone kind of rushed and said, well, wasn't there a severability clause? Like if one section was deemed unconstitutional, like that section would go out and, the rest would be whole. And we kind of went back and it did have a severability clause, but, notwithstanding that severability clause, I guess kind of what you're saying was because the single subject rule was violated, the court said, the whole thing's amiss. Is that right?
Yeah, and how unusual, lawyer to lawyer, right? That the severability that the judge didn't preserve, the rest of the proposition, right? And only strike down their very narrow section that, in this case, the judge felt was unconstitutional, and preserve the rest of it, right? Like sever off that piece, keep the rest, and preserve the will of the voter, right? That could have been divined around it, but struck the whole thing down. Really kind of an unusual and exceptional decision by a judge. So,
and so I guess constitutionally, I guess what was the argument that, these gig companies put forward that, ultimately didn't prevail?
Well, they're still working on it right now. And I guess their argument is basically that, this idea that there was more than one argument that they're in this ballot initiative, and therefore the whole ballot initiative should fall, is erroneous, right? And is wrong as a matter of law. And so that's the argument that I think they're focused on here, as just a pure question of law.
Right. And, I guess in the past, it was a pretty high standard, you had to meet the test on the single subject rule. It's pretty shocking, before this proposition was, put into place, I'm sure it was vetted by teams and teams of lawyers. So it had to be a pretty big surprise.
In order for it to even be certified as a ballot initiative with a statute that was implemented, it certainly had to go through lots and lots of review, right, in order to be qualified.
Right.
So how unusual for one judge to, ex post, take a look at it after all this time, after all the public debate, after it's been implemented, after the vote, after it's been implemented, and then to say, no. There's more than one subject here. And this is the justification for striking it down. Yeah. I mean, you can disagree with the policy. You can say, I think workers deserve different standards, right? We can have that debate, and we can say, listen, I'm a strong consumer advocate. I want the best for workers, but I also believe workers should be able to choose for themselves what is best for them.
Right.
But we can have that debate on the policy question, but it feels like California's kind of settled it, right? It feels like you all voted and made a decision, but a little weird for me that one judge can say, I don't know. I know better. I know better than the legislature. I know better than the people who certified the initiative, and I know better than, more than 10 million Californians.
Right. So, I guess, we were all shocked when this was overturned. Kind of when's the appeal going to be heard? And I guess when can we expect the new ruling?
Actually, I haven't been tracking the actual date of the appellate court hearing because I've just been so focused on the legal argument. So I apologize. Right. I don't know the date off the top of my head.
No worries. We'll have to get that for our listeners so we can kind of check it out and follow along. Tim, if some of us want to follow you socially or, see what's going on with you and follow this case and get some more information from you, I guess what's the best way to kind of check you out and follow along?
So I have my own Twitter page, I'm on LinkedIn. I actually have a whiskey company. So you can find me on Instagram as Blue Run Tim. So I get to do fun things on the side. I'm not just a constitutional lawyer. I also sell fun whiskey. So lots of places to find me.
It'll have to be the next episode. Well, awesome.
Yeah, no. Or we could do this with whiskey. It's even more fun that way.
I know, exactly. When the appellate ruling comes out, we'll have to have you back on with the your whiskey, and we'll go through it. But
yeah, we'll drink every time somebody says something like, one subject rule or something like that.
Exactly. Looking forward to it. Well,
Good.
Tim, thank you so much for joining us, and we'll look.
It's been a pleasure.
Appeals case, and thanks for kind of peeling back that layer and kind of informing us kind of what the heck happened there. So
a little bit of crazy. So
exactly. Never a dull moment here in California. So
great. Thanks so much for having me.
And thanks for joining us.
My pleasure.